My tip focuses on research. When I was in law school, the partner at the small firm I clerked for told me, always go to the code. And I still use that phrase as one of my work mantras to this day. The fact that immigration law is so code based is one of the things that attracted me to it in the first place. The code will always be your starting point. So, what do I mean when I say always go to the code? Well, the foundation of our nation's immigration laws is codified at Title 8 of the United States Code, or 8 USC, also known as the INA or Immigration and Nationality Act. The form of relief you want to apply for, or any issue you are facing in removal proceedings, has its basis in the INA. So before you start analyzing or Googling, it is important to check the INA to see what it says. But how do you do that? There are various ways to find the provisions of the INA. You can use CILA's resource, Helpful Resources in Representing Unaccompanied Children, which has links to the official online sources of the US Code. I also like to go to the links to the INA from the USCIS website. And as a plus, all the subjects of each section are listed. This is helpful because one of the problems you might have is not knowing where to actually look in the INA to find the part that corresponds to your issue. Another way to find the correct INA section for the type of relief you are working on is to use a CURSBAN. CURSBAN is a large horn book that is often referred to as the Immigration Bible. However, CURSBANs, which is published by CILA, is quite expensive, and many nonprofits, in my experience, may have a copy or two, but they're several years old and may be out of date. Another option for many of the common issues we come across is to use CILA's Pro Bono Guide. It has sections on asylum, withholding of removal, and CAT, SIJS, and adjustment of status, UNT visas, family-based cases, and VAWA self-petition. It also has a lot of information on removal proceedings. And there are a ton of links in each section, including to the INA. Once you figure out which section of the INA you need to be looking at, you can read it and the elements you need to prove for your issue. This should always be your starting point because the law, as written by Congress, is the basis of everything we do. Also, there hasn't been a major overhaul of the immigration laws since IRA in 1996. So the code is the most stable place to go for answers. One thing I haven't mentioned yet is the companion to the INA, the immigration regulation. The executive branch, as the part of the government tasked with enforcing the laws that Congress makes, is allowed to create rules known as regulations that interpret the law they are enforcing. The majority of the regulations that interpret the INA are contained in Title 8 of the Code of Federal Regulations, also known as 8 CFR. These regulations will also help you determine what further requirements might apply given DHS or DOJ's interpretation of the INA. The government has developed a website for the CFR at ecfr.gov. However, I do want to warn you that the ECFR may include regulations that are no longer in place. Due to the number of largely immigrant unfriendly regulatory changes that were made under the previous administration and the litigation that ensued, several regulations are enjoined by nationwide injunction. A good example are the asylum regulations at 8 CFR 208, which were part of the Mammoth Asylum Rule that was supposed to go into effect in January 2021. But were enjoined by a federal district court in the Pangea case. Unfortunately, there are not a lot of sources to tell you which regulations are good and which are not. So it will require staying on top of the immigration litigation news to puzzle it out. Make sure you check out CILA's website for our legal updates and attend our working groups to get the latest information and the on-the-ground trends.